Hello everyone, welcome back to my channel. Cheryle Hubbard Walker, County for real. So I'm in the kitchen. Uh, just put me some homemade cupcakes in the oven. They starting to rise. So while I'm waiting on the cupcakes, what I want to do is just read a little bit from my book right here. This is business law. So just read a few little items from my business law book. And the lighting is better in the kitchen, so that's why I like to do a lot of my videos in the kitchen. Lighting is better. I have to purchase some other lighting for my living room, so I might try to do that as soon as possible. Uh, okay. Okay, first I guess I can start out right here with some of the amendments. The Bill of Rights. The first 10 amendments are the Bill of Rights. The First Amendment, freedom of speech and religion. Second Amendment, right to bear arms. Third Amendment, the quartering of soldiers in homes is prohibited. Fourth Amendment, search and seizure by probable cause. So there would be so basically, no illegal search and seizure. So in other words, you have to have probable cause. Fifth Amendment, grand juries, double jeopardy, incrimination, self-incrimination, due process, and eminent domain. Eminent domain, in other words, the government want to buy your property, they have to pay you. So that's eminent domain. We have the Sixth Amendment, procedures allowed in criminal cases. Seventh Amendment, jury trials and common law cases guaranteed. So in other words, right to a fair trial. And that's also the Fifth Amendment too. So Fifth Amendment, double jeopardy, self-incrimination for the Fifth Amendment. You don't have to testify against yourself for fear of self-incrimination. That's the Fifth Amendment. Let's do number 8. Eighth Amendment, Bill of Rights, guaranteed cruel and unusual punishment prohibited. Amendment 9, people retain other rights. Then you got the 10th Amendment, powers reserved to the states. So no, I guess each state have powers. They said powers reserved to the states. So each state has their separate, each state has their separate powers. Then we have the 11th Amendment, lawsuits against the states. Amendment 12, president and vice president elected together. So in other words, the 12th Amendment, that's when they're talking about, vice president and the president, electing the president. And I know that president can only serve, I believe, 8 years. And then they have some other stipulations. In other words, if somebody is the president, and then if that president was impeached or something, then the vice president would step up and be president. So then we have slavery is abolished. That's what I was looking for. Slavery was abolished in the 13th Amendment because back in the day, so matter of fact, this is Black History Month. And so slavery was abolished, the 13th Amendment. So I also have here, I want to give thanks to Harriet Tubman, American abolitionist and political activist born into slavery, escaped slavery and made 13 missions to rescue 70 enslaved people, including family and friends, using safe houses, which they call the Underground Railroad. Then we have Frederick Douglass. He also escaped slavery. He was born 1818, 1895. He escaped slavery in Maryland. He was an abolitionist, writer, and orator. So in other words, he was abolitionist as well as Harriet Tubman. In other words, they wanted to abolish means to get rid of. They wanted to get rid of slavery, do away with it. So they did that in the 13th Amendment. Christmas addicts, multiracial man that escaped slavery. Carter Godwin Woodson, American historian, author, journalist, and founder of the Association for the Study of African American Life and History. Sojourner Truth, abolitionist as well, wanted to abolish slavery, get rid of slavery, born into slavery, escaped slavery with her infant daughter to freedom in 1826. Nelson Mandela, South African anti-apartheid revolutionary political leader, also was the president of South Africa from 1994 to 1999. Then I also have Denmark Versailles, have Marcus Garvey, Elijah Muhammad, Medgar Evers, Dr. Martin Luther King, Coretta Scott King, Emmett Till, Huey Newton, Booker T. Washington, Mary McLeod Bethune. We have Thurgood Marshall. So these are just a few of the people that we recognize, when it comes to Black History Month. So, back in the day, our ancestors, they had to sit in the back of the bus, and they couldn't sit. Even some restaurants, they couldn't even go in. They couldn't even go in because, and then some of them had sit-ins in various counters and in various restaurants. So things have tremendously gotten better. So over the years. So thank God for Martin Luther King, Rosa Parks, and a whole lot of other, prominent people that, that we need to thank. They're not here right now, but, you always thank them in your prayers. So we'll be thanking them forever and ever and ever. Because, see, if it wasn't for them, we'd be still sitting on the back of the bus. And so, I'm just glad those days are behind us. And so that was the 13th Amendment that abolished slavery. So then we have the 14th Amendment, equal protection of the law, due process, and citizenship. So due process is also the 5th Amendment too. So I also have it in the 14th Amendment. And then we have 15th Amendment, voting rights guaranteed. In other words, voting rights. That's why they tell everybody to get out there and vote. Because back in the day, we couldn't, our ancestors couldn't vote. Women were given the right to vote. But back then, some time ago, sometime in the past, they couldn't vote. Women couldn't vote. Our ancestors couldn't go to school. They couldn't pick up a book. They couldn't study. Frederick Douglass, when he went to jail, he was self-taught. He taught himself how to read. So thank God that, we had Martin Luther King, Harriet Tubman, Rosa Parks, and, Coretta Scott King, and all those, important people in our past, in our history. So that's why they have Black History Month. Well, thank God they fought for our rights, because that's why I always tell my family, my friends, and some folks that's younger than me. I say, go ahead and get your college degree. Get your college degree if you can. Everybody, it's a time for everything for when it comes to that. Because everybody, sometimes you might have things you have to do in your life. Some people have to work, and they might not have time to take out to go to college. But if you ever get the opportunity, I would say go. If your finances are in order, and you have it's the right time for you, you have that opportunity, I said, why not do it? So I thought about those things when I went and got my degree, Strayer University right here in Washington, D.C. So I thought about those type of things and what our ancestors went through in the past. And I always said that if I had the opportunity, because see, I already knew if I had the opportunity and I knew my finances were intact, and I knew that was the right time for me to go, then that's when I went. So sometimes you have to take your opportunity when it comes along, because sometimes some things don't come but once in a lifetime. So I took my opportunity and went down to Cheryle University right here in Washington, D.C. and studied my bachelor's and I did my master's right down there. So I said, everybody's not fortunate to be, you know, I'm not a wealthy person, but I had that opportunity, so I took it. So, and that's what I'm saying. I would just say, always tell folks that's younger than me, and even folks, people that's my age. If you have the opportunity, you have the time, you have the finances, do it. Because back in the day, our ancestors, they couldn't even go to school. They couldn't go to school, they couldn't learn, they couldn't study. Back in them days, slavery times, and even after that, so if you have the opportunity, go ahead and do it. Do it. I always try to inspire and empower someone. I always try to empower and inspire someone. So if I can be an inspiration to you, let me know. Then we have the 16th Amendment. The income tax is established. 17th Amendment. Senators elected by direct election. So in other words, the senators in the House, the House of Representatives and the Senate, so they have to be elected. 18th Amendment prohibition established. We had the 19th Amendment, women given the right to vote. See, as I said, we couldn't vote back then. We couldn't do nothing. Our ancestors, so the 19th Amendment, women were given the right to vote. So they're telling everybody, get out there and vote. Get out there and vote. And like I said, if you have an opportunity to go to college, go. When I was in college, I loved being in college. I didn't mind. When I came home from classes, all I did was study. You would think that some people that could leave school, when they get out of class and come home, they be like, I don't want to see no books. Really? So, but but I was one of those people that always picked up a book. Always picked up a book. So I remember my teacher, my business law teacher right here in Washington, D.C., Cheryle University. We used to have to, in other words, he would give us a certain amount of chapters to read. So then when we get to class, we had to, you want to already have read your chapters that the teacher told you to read. So he would catch us off guard and call us, different ones. Oh, you come up to the classroom. You come up to the front of the class. You come up to the front of the class, Hubbard, Walker, and you explain the term entrapment. Explain the term contract. So in other words, we had to go to the class, go in front of the class, and he might give you a word, like contracts or like I said, entrapment or some other kind of legal term. What about mens res, actus reus? He might say, go to the board and explain it. So we just had to go to the board and explain it. So one day my teacher came back and he said, look, I got 3 people in this class the teacher said that. He said, I have 3 people in my class right here that should go to law school. And he called my name and the whole class started clapping. He called my name and two other people's names. And one gentleman came back the next day. He said, look, guess what? I'm going to law school. So he probably finished law school. So I did a paralegal course, but I didn't finish law school. So I just did my bachelor's and my master's down in Cheryle. But I did a legal assistance course. So I got my legal assistant diploma. But I still always keep abreast of different things going on in the law community. That's why I keep this book here. And then I have a couple other law books. And my husband, he had a whole set of law books that I have here too. I have a whole set of law books. And these are just the updated ones. So I have about three law books that's more updated than the set that I have. So, and then we have Amendment 20, terms of President, Vice President, Senators, and Representatives altered. And the 21st, prohibition repealed. 22nd Amendment. President's terms limited to 2 years. Oh, not 2 years. I mean, 2 terms. 23rd Amendment, Washington, D.C. guest electors. Amendment 24. Excuse me. Amendment 24, poll taxes outlawed. Amendment 25, disability of the president. Vacancies in the vice presidency. Amendment 26, we have vote extended to 18-year-olds. So in other words, you have to be 18 to vote. 27th Amendment, it's 27 amendments altogether. Congress prevented from voting itself instant pay raises. So those are the 27 amendments. So let's go into statutory law. A law passed by a legislator is known as a statute. So your statutes are your laws. At the federal level, statutes are the laws made by Congress and signed by the president. At the state level, statutes are enacted by state legislatures such as the Ohio General Assembly or the Oregon Legislative Assembly. Many statutes prohibit certain activities. Most criminal statutes are prohibitive statutes. Okay, let's go over here to common law. Court decisions. When most people think of the law, they think of the Constitution or of statutes passed by Congress and the state legislatures. While these two sources are important, they are not the only two sources of law in this country. The courts also make law by following the common law and precedent through the interpretations of statutes and through judicial review. Common law. The term common law arises from the attempts of the early English kings to establish a body of law that all the courts in the kingdom would hold in common. At that time, judges were sent to the towns and the villages of the kingdom with instructions to settle all disputes in as consistent a manner as possible. The judges maintained this consistency by relying on previous legal decisions whenever they faced a similar set of circumstances. In this way, they began to establish this body of common law. As the process continued, judges began to write down their decisions, which they call stare decisis. This body of recorded decisions became known as common law. The process relying on these previous decisions is called stare decisis. The past decisions themselves are referred to as precedents. So in other words, back in the day when judges, how they made law. Judges make law, not the police officers. So the judges are the ones that make the law. So the police officers just enforce the law. So in other words, back in the day, judges went down in the town and the villages. So when they went down in the town and the villages, when they solved those cases, they became laws. They became laws on the books. So that's what they call precedent. They became important cases. In other words, when they went back and they went to solve other cases, they used those cases as precedent. And when they looked at newer cases, they looked at the cases that they already solved. So in other words, they had a similar case and it was already made into law. Then they looked at that case when they want to solve other cases. That's what they call precedent. That's like an order of importance. So that case was solved. That decision was made on that case, stare decisis. And so when the judges looked at other cases, they, that's how they made their decisions based off of other cases. That previous case became a precedent case. So let's see how the Cupcake doing. Oh, they almost. Oh, they're almost ready. So now let's look at let's move on to another chapter. Okay, well, let's talk about utilitarianism and rational ethics. The answer is no. The utilitarian principle states that an action is good if it promotes the greatest good for the greatest number of people affected by the action. So utilitarian. This principle clearly demands that the bartender, customer, and social or business host refrain from giving another drink to someone who is obviously inebriated. So in other words, if you go to a club or a bar and the bartender know you already drunk, I mean, don't give that person that's already drunk, don't sell them another drink because you clearly see that they already drunk. See, the negative consequences of such an action include not only the physical damage to the unfortunate individual, but also the likelihood that that person will injure or kill someone, right? Because you see that person is drunk, and then they got to go out there. You don't know if they're going to have to drive. They sitting at the bar, they drinking. So that is the utilitarian. So let's see. They also have the Drug-Free Workplace Act, Uniform Controlled Substance Act, vandalism, malicious mischief in some states, and criminal damaging in others is defined as willfully or maliciously causing damage to somebody's property. If the value of the damaged property is not very great, the charge is a misdemeanor. Vandalism may also be considered a felony, however, especially if the damage is extensive. In other words, you go damage somebody's property, and depending on how much damage you cause to that property, it could be a misdemeanor or a felony. So in other words, I believe it's less than 500, if I'm not mistaken, it would be a misdemeanor. Anything over 500, I believe, would be a felony. But I could be wrong. It doesn't say it right here. Let me see. Okay, here it is right here. It says, because the cost of repairing the damage resulting from vandals is so high, young vandals are often required to pay the cost or provide the work needed to restore the damaged property. However, under parental liability laws, the parents of vandals are also often referred to pay for the damage done by their children. So in other words, you have a child and they go out there and damage somebody's property. I guess if they under 18, let me see if they under 18. It don't say, the book doesn't give me an age. It could be 18 or even 21. It says the amount of the parent's liability is limited, ranging from $300 in some states to $2,000 in others. To be guilty of vandalism, an individual does not have to be the person who actually does the damage. Really? Anyone who keeps watch for passers-by while others commit the act is guilty too. In other words, you see somebody committing a crime and you don't report it, then you just as guilty as the person that committed the crime. So in other words, that's what they're saying. Because they're saying anyone who keeps watch for passerby while others commit the act is guilty too. So you see somebody destroying somebody's property, and I guess that's what they're saying. Any other kind of crime, as well. You see somebody doing something and you don't report it, you just sit up there looking. So in other words, it talks about health and safety in the workplace under the Occupational Safety and Health Act, which created OSHA, is an agency responsible for the Department of Labor. The government set up standards that employers must meet. All businesses affecting interstate commerce are covered under this statute. This means that under the Occupational Safety and Health Act regulates over 6 million businesses and more than 80 million employees. In its attempt to deal with such unimaginably large numbers, it can employ a number of tactics. Those include inspections, the hazard communication standard, record keeping fines, and mega fines. The right of free speech. The First Amendment of the Constitution guarantees that people will have freedom of speech. This right protects all forms of political expression, not just those with which we agree. If the First Amendment protected only the ideas of the people in power, then it would be useless. In fact, it would be very much like the 1961 Soviet Constitution, which guaranteed the people of Russia and other Soviet states certain rights as long as the exercise of those rights did not contradict the plans of the Communist Party. Freedom of speech can have an impact upon the business persons in a number of different ways. Okay, let's see. All right, let's see what we have. I try to pick out the ones that I know that's important. No, all of them are important, but oh, okay. Definition of a crime. A crime is an offense against the public at large. As such, a crime threatens the peace, safety, and well-being of the entire community. For this reason, a crime is punishable by the official governing body of a nation or state. Also, for this reason, the state or the federal government representing the public at large is the prosecution, that is, the one who brings the criminal action. As in the case of a civil lawsuit, in a criminal action, the person accused of the crime is called the defendant. No act can be considered criminal unless it is prohibited by the law of the place where it is committed and unless the law provides for the punishment of the offenders. And so then we have the criminal law in the American system. We have the federal criminal law, classes for crimes. So in other words, the classes like a misdemeanor or felony. So a felony is a crime punishable by death or imprisonment in a federal or state prison for a term exceeding 1 year. Some felonies are also punishable by fine. Some states define a felony as a crime subject to punishment by hard labor as an infamous crime. A misdemeanor is a less serious crime that's generally punishable by a prison sentence for not more than 1 year. We have fines, we have imprisonment. We also talked about requisite state of mind. Generally speaking, a crime cannot be committed unless the criminal act named in the statute is performed with a requisite, that is, required state of mind. Many state criminal codes include 4 possible states of mind: purpose, knowledge, recklessness, negligence. Individuals act with purpose when they act with the intention to cause the result that does in fact occur. For example, if a young man were to point a loaded gun at his ex-girlfriend with the intention of shooting her, and if he actually were to shoot her, he would have acted with purpose. In other words, most crimes are built on intention. So in other words, you have a gun, but you're cleaning it, and it accidentally goes off, but you didn't have no intent behind it. You didn't have the intent on hurting nobody. You was just cleaning it, and a bullet went out the window, but you should have made sure there wasn't no bullets in there. So that's almost like negligence right there. But you didn't have the intent on hurting. You didn't intend to hurt nobody. So that's what they're saying. Most crimes are built on intent. In other words, it won't be like you just actually took the gun and just shot somebody. You was cleaning the gun and you mistook the bullet. There was one bullet left in the chamber and it went out the window and it hit somebody. So it wasn't no intent behind it. You didn't intend to hurt nobody. You didn't intend to shoot no one. So that's what they're saying. It says individuals act with purpose when they act with the intention to cause the result that does in fact occur. For example, if a young man were to point a loaded gun at his ex-girlfriend with the intention of, but if he pointed at it, he intended on hurting her, then that's something different. Some states choose to call this mental state intent. Intent or purpose should not be confused with premeditation, which is often an added condition in the case of aggravated or first-degree murder. If the young man had also planned the shooting of his ex-girlfriend stalked her and finally decided there would be premeditation. So if he stalked her and he planned that he stalked her and he intended on, that's first degree murder right there if he would have killed her or something like that. When people act with an awareness that a particular result will probably occur, they act with knowledge. Then we have recklessness. A person who acts with recklessness shows a perverse disregard of a known risk of negative consequences. People act recklessly when they are indifferent to such a risk. If two drivers were to challenge one another to an illegal drag race on a public highway, they would be acting recklessly. Yeah, because if you want to challenge somebody to a race and you speeding down the highway, you could, you're not showing enough due care because you could actually harm someone and yourself. They would be acting recklessly. In other words, they would have disregarded the possible serious consequences of their decision to engage in an illegal drag race. Negligence. People act with negligence when they fail to see the possible negative consequences of their actions. A young man who cleans I was just talking about that, cleaning a rifle and it accidentally went off. See, here go one right here. Here go the example. A young man who cleans a hunting rifle without checking to see if it's loaded would be acting with negligence. This designation applies because she has not bothered to look for any possible negative consequences could result from her actions. The designation applies because she has not bothered to look for any possible negative consequences that could result from her actions. Criminal negligence should not be confused with negligence in tort law. In tort law, negligence is concerned with the compensation of accident victims. So, then we also have assault and battery. The unlawful touching of another person is called a battery. An accidental bumping of another person in a crowded hallway or in a checkout line at the supermarket would not be battery because you didn't have no intent behind it. You accidentally bumped into somebody. You didn't intend on harming nobody. I accidentally bumped into you. Oh, excuse me, assault is an attempt to commit a battery. Pointing or shooting a gun at someone is the assault. The bullet striking a person is the battery. So if somebody point a gun, that would be an assault, but you actually shoot that person would be a battery. Simple assault and battery are generally misdemeanors. Aggravated battery and aggravated assault, however, are felonies in most states. To qualify as an aggravated offense, the assault or battery would have to be committed with a deadly weapon, with the intent to murder, with the intent to commit rape, or with the intent to commit robbery. Some states call aggravated assault felonious assault. We have kidnapping, sex offenses. This is a real good book right here. This is my business law book. Business law. So, then we have crimes involving business. You have embezzlement, bribery, larceny by false pretenses, forgery, the false making or changing of a writing with the intent to defraud is forgery. Racketeer Influence in Corrupt Organizations Act, one of the most controversial business-related criminal statutes today is the Racketeer Influence in Corrupt Organizations Act. In an attempt to prevent a criminal invasion of legitimate businesses, Congress passed the Right Code in 1970 under provision of the statute conducting a legitimate business with the funds acquired from a pattern of racketeering activities can give rise to both criminal and civil liability. Many other offenses that fall within the scope of racketeering activity, such as arson and robbery, are serious crimes. Others, however, are less sinister. For example, both mail fraud and wire fraud fall within the definition of racketeering activities. mail fraud, and wire fraud. So that's racketeering. Crimes involving computers. You got committing crimes by computers is becoming commonplace. Like many inventions, the computer has helped make our lives easier. However, it has introduced new ways to commit crimes. Both the states and the federal government are dealing with this new legal problem in a variety of ways. In other words, also, yeah, people committing crimes with computers and all that stuff. And also, you have hackers. You have hackers that get in and try to infiltrate your system. So hold tight. So let me check on these cupcakes. Oh, they are ready. They are ready. These are, see, they are ready. They ready. So, oh, they're gonna be good. So, let them sit over there and cool. So let them cool, and then this is the icing that I made, homemade icing. It's gonna be not thick, but it's cut that off. Okay, let's finish reading a little bit. So let them cool off a little bit. Let's get back to the reading. Okay, let's see. I was talking about computer crimes. We have the states and computer crime. The states and computer crime. The states have attempted to stop computer crime in 3 different ways. Some states have created a crime of computer trespass. This approach simply outlaws the use of a computer to commit any crime. Other states have passed computer fraud statutes. So in other words, states have passed statutes, computer fraud statutes. So in other words, if somebody commits a crime with their computer, then they have laws for that too. So, then we have tort. Tort is a private wrong that injures another person's physical well-being, property, or reputation. The English word tort comes from the Latin word tortus, tortus, which can be translated as twisted. A person who commits a tort and has thus engaged in this twisted behavior is called a tortfeasor. The other party is alternately referred to as the injured party, the innocent party, or the victim. If a lawsuit has been filed, the injured party is called the plaintiff, and the tortfeasor is called the defendant. Then we have the element of duty. One approach to law is to think of the legal liability in terms of elements. The existence of legal duty. Duty is best understood in relation to rights. Legal duties arise because one of the objectives of the law is to promote justice. Justice demands that people be allowed to enjoy their health, property, reputation, business relationships, and their privacy without the unjust interference of others. So you can't interfere with nobody. and they trying to enjoy themselves. They have the right, like with your neighbors, you have the right to quiet enjoyment. So your neighbor's not supposed to disturb you and, cause a disturbance, because that's come from, I guess that would be under like landlord and tenant court situations. We have assault, and assault occurs when a victim is placed in fear or apprehension of immediate bodily harm by a tortfeasor who has a present apparent ability to inflict that harm. Then we have a battery, involves an offensive or harmful, unprivileged touching. So somebody touched you the wrong way, and you didn't want them to do it, and they did it with an intent to harm. That is a crime. But if they accidentally bump into you, that would be something different. That would be like, oh, sorry, excuse me, and that would not be a crime. So, but with an intent to harm is where they come in to that criminal offense. False imprisonment, when one party prevents another party from moving about freely. The first party has committed the intentional tort of false imprisonment. Defamation, any false statement communicated to others that harms a person's good name or reputation may institute the tort of defamation. In other words, if you say something about somebody that's not true, and it really harms them, but if it's not true, that's like defamation of character. But in other words, if it is true, then it probably wouldn't be defamation. But if you say something about somebody and it's a lie, you're defaming their character. So that's why I said it says a false statement. Any false statement communicated to others that harms a person's good name. They say something about me, harm my good name, and it could be false. That's defamation. Then we also have slander. Defamation in a temporary form, such as speech, is slander. So if you speak it, you say something wrong about somebody, or you give a false statement about somebody, and it's not true. What's false is when it's not going to be true anyway because it's false, and that would be slander. So that's like the spoken words. Then you have libel, Libel. Video cassettes or laser disc is libel. In other words, you put something on a recording or something about somebody that you know is false. You give a false statement in a recording. That would be Libel, libel. People can usually bring a libel suit even if they have suffered no actual loss. Whenever the permanent statement is damaging to their reputation, is false, and is communicated to a third party. In other words, you communicate something false about somebody to a third party, then you can be sued. Then we have actual malice, meaning that the statement was made or printed either with the knowledge that it was false or with the reckless disregard for the truth or falsity. So, invasion of privacy, when one person unreasonably denies another person the right to be left alone, invasion of privacy. Let's see, I think I'm going to stop right here. We also have negligence, elements of negligence. You see, negligence is that part of tort law that is concerned with the compensation of accident victims is called negligence. In other words, they say you drag racing or something like that. You drag racing and you didn't show enough due care. You drag racing down the street and then you hit a man in the street, but you out there drag racing with another car, so that's negligence. And it says elements of negligence, legal duty, a determination that a legal duty exists between the parties must be made to establish liability through negligence. You have breach of duty. The judge or the jury must determine whether the person accused of negligence has breached the duty owed to the victim. Breach of duty occurs if the tortfeasor has not met the appropriate standard of care. This means that the alleged tortfeasor has failed to be careful enough. That's what I'm saying. He didn't show enough due care. He wasn't careful enough under the circumstances. To determine if the alleged tortfeasor has met the standard of care, the court uses the reasonable person test. In other words, would a reasonable person have done that? Of course not. This test compares. So, cause see, I'm a reasonable person, and I'm not gonna be out there drag racing. So it says this test compares the actions of the tortfeasor with those of a reasonable person in a similar situation. If a reasonable person would not have done what the tortfeasor actually did, then the tortfeasor is liable. The reasonable person test is objective. Circumstances may change, but a reasonable person does not. Then we have defenses to negligence. We have contributory negligence. So in other words, how much did you contribute towards the negligence? Were you 100% negligent or 50% negligent? See, the defense of contributory negligence involves the failure of the injured party to be careful enough to ensure personal safety. In other words, if the injured party's negligence contributed to the personal injury, the tortfeasor wins. Comparative negligence, to soften the harsh effects of contributory negligence, many states have adopted comparative negligence statutes that require courts to assign damages according to the degree of fault of each party. As I said, what percentage? 100%, 20%. Rather than deny all recovery, the court weighs the relative degree of wrongdoing in awarding damages. If the tortfeasor was 80% negligent, the injured party may be allowed to recover for 80% of the losses suffered. Some states have adopted the 50% rule. Under this rule, an injured party who was found to be more than 50% negligent cannot recover any damages from the tortfeasor. So this is the last one I want to go over. Strict liability. Under certain circumstances, the courts may judge a person liable for harm, even though that person was not negligent and did not commit an intentional tort. The doctrine is known as strict liability or absolute liability. So under strict liability, the court will hold a tortfeasor liable for injuries to a victim, even though the tortfeasor did not intend the harm and was not in any way negligent. Strict liability is generally applied when the harm results from an ultra-hazardous or very dangerous activity. Such activities include using explosives and keeping wild animals. A number of dangerous activities such as flying an airplane, operating X-ray equipment, and laying public gas lines are not subject to strict liability. These activities are recognized as essential to the economic health and welfare of the public. We have product liability. Product liability is a legal theory that imposes liability on the manufacturer and seller of a product produced and sold in a defective condition. Anyone who produces or sells a product in a defective condition is subject to liability for the physical or emotional injury to the ultimate consumer and for any physical harm to the user's property. The courts have regularly held that liability for a defective product extends to the producer of the product and the wholesaler and the retailer. So in other words, you buy a product from somebody and it's in a box, you get it home, you open that box up and it boom blows up in your face. It blows up in your face and it burns your shoulder or hurts your hand or burn your forehead, bruise your forehead or something. So in other words, the manufacturer, the retailer, and I think it was a wholesaler. No, it says the the user, not the user, but it says it says the retailer. Yes, it's a wholesaler. So in other words, the product. So it extends to the producer of the product. In other words, who produced the product? The wholesaler sold it to you, and in other words, the wholesaler sold it to the retailer, and the retailer sold it to you. But so the product, the wholesaler, and the retailer, so they could be liable if something, you open the box and it boom blows up in your face, or burns you or cuts you. You open it and it was a sharp piece of. You open the box and it was a sharp piece of, one of the parts was real sharp, and it cut your hand. You had to have, stitches or something like that. So remedies for torts, so that's the end of that chapter. And Okay, so I think that's all I'm going to read today out of this book right here, Business Law. And this is the 8th edition, Gordon Brown, Paul Soups, and Mary Ann Lawler. So, class, I want to say that's all I'm going to read today. And I want to check these cupcakes out and see how they taste. So, also I have so this is what we drink all the time. This is a mineral water. It's good for you. So I don't want to drink, nothing sweet. I don't want to have nothing sweet. So sometimes you gotta drink a little water. And that's let's say the cupcake. Oh, they cool real good. See, very nice. And see how you pick them up like this? Smell good too. Let me try one. So just just to try. Good. And cupcake. See? So I didn't make them real sweet. So that's a good thing. Didn't make them real sweet. Didn't make them real sweet. Um, Class, I'm going to close out today. I want to say thanks for being here today. And I'll see you on my next video. Enjoy these cupcakes. Pass them down to the family.